two.
Correct. Colleagues, I believe let's start with our meeting. Let us observe a moment of silence and meditation, please. Thank you. The agenda was circulated, and I believe all of us, we do have copies of the agenda as the screens are not working. Let me first apologize for the inconvenience we might have caused as the committee and coordination. Remember, this committee does not fall under committees which are discussed in programming. So whenever we have to have a sitting, we have to engage with the administration and check for the available time, which we can utilize as the committee. We scheduled a meeting earlier, which clashes with many things. I think it was 3 weeks back. Then we decided that the meeting must be held during this week. Hence, we decided on today's date. When we were in the process, we could find that programming has scheduled many plenaries for this week and next week. But the matters in front of the committee are urgent because they have been with us, especially the first matter. They have been with us. We have to report back to Parliament on the issues. So if we delay, it would mean we are not, it would be alleged that we are not taking our work serious. Hence, we requested this day. And we had initially planned it for 11, but some members were engaged either in virtual meetings or in physical meetings. And in the process, the officials who are supporting the committee have to go and support the plenaries, which are scheduled for today. And this House committee room where we are in will be having a plenary, mini plenary at 2. So in our engagement, as much as we'll plead that we take the matters presented to us seriously and deliberate on them, but we must be cautious that at least by 1:30 we have to be out to afford the latest, the officials who are here to be able to go and discharge their delegated responsibilities. That's my plea to you, honorable members. And I believe we can do that because the matters were circulated to us at least long ago. We should have done our homework and would wish that as much as we'll give our dedicated time, but we'll be able to take consideration of 1:30 the latest. Thank you, honorable members. Mr. Ngaleka, are there any apologies?
Yes, Chair. We have apologies from Mr. Mikalakis and Mr. Ndlela.
Mr. Machalakis? Okay, that's the apology and, okay.
Greetings, Chair, greetings, colleagues, and greetings to the support staff, Chair. If I may, on behalf of Honourable Leanne Matthys and Honourable Umpile Mahotwe, I'd like to tender an apology on their behalf.
Okay, thank you. Then the other apology is the apology of Honourable Meka Motlauli, who I believe is still chairing his committee now, but would join us immediately. He sent a message, would join us immediately when he has wrapped up with his meeting which he is chairing. The apologies are presented to the members of the committee. Any member to accept the apologies? Honorable Kaleka. Any seconder? Okay. Okay, let's move to item number 2. Item number 2, the agenda is flighted now. Item number 2 is a consideration of the agenda. As I indicated, the agenda is presented to us. Any hand? And Honorable Scott?
Oh, no, it's fine. No, thank you very much, Chair, and good afternoon to everyone. I move for the adoption of the agenda. Thanks.
Any second? Consideration of the minutes, okay, the second was Honorable Mani for the agenda. Consideration of minutes, I assume that we read the minutes. Are there any matters on page 1? Honorable Mani?
Yeah, thank you, Chair. Firstly, I must welcome that the minutes were circulated on time, and I think the meeting can take them as read, and I move for the adoption of the minutes.
Seconder? Thank you. Thank you, honorable members. Honorable Vessel, second the adoption of the minutes. Let's move, honorable members, to item number 5. On this item, let me request Honorable Mr. Ngaleka to take us through.
Chair, matters arising also in the agenda. It's the matter of Mr. Reddy. The meeting will recall that after it had received the referral from the Speaker, it resolved that under the signature of the Chair, it should write to Mr. Reddy, forward him with all the documentations that went with the referral, and that it asked him to provide his version of the event or explanation. Mr. Reddy did respond, and the matters arising, my colleague, Mr. Tijana, will take us through, and yeah, thanks, Chair.
Thank you, Mr. Ngaleka. Mr. Tejana, can you please take us through?
Good afternoon, Chairperson, and good afternoon to honorable members and my colleagues. I'm not sure if I'm audible or not. My voice is not the best in the world. Chairperson, the reason why we are here to address you regarding this matter is just a question of playing devil's advocate, because our experience over the past 5 years is that half of the matters that serve before this committee, they end up in court. And also, Chair, if I may preface my discussion by saying we have been supporting this committee for the past 5 years, Chairperson. And in the past 5 years, this committee has been taken to court not less than 6 times. And on those 6 occasions, this committee has a 100% success rate. And there's a reason for that. And the reason for that, Chairperson, is that in the past, we have always tried to persuade members not to be sectional or sectarian when they look at issues. We know that members belong to different political parties. And of course, they come here holding their mandates from their parties and so on. But we always say, look, even though this meeting seems to be happening in closed walls like these ones, but the fact of the matter is that half the time these things land in court. So we just want to caution members to say, let's deal with issues on the table dispassionately. Chairperson, we just want to guide the committee, and of course, we're not members of parliament. The committee will decide which route it wants to take. Having looked at the, I'm assuming that the members have had sight of the video footage, and of course, they've gone through the unrevised Hansard. Chairperson, perhaps let us start with what I would refer to as a, technical legal argument. Who are we? What are we about? I mean, as this committee. And the answer to that, Chairperson, is on Section 12, subsection 1 of the Powers and Privileges Act. And that section deals with disciplinary action against members for contempt of parliament. And it reads as follows. Subject to this act, a house has all the powers which are necessary for inquiring into and pronouncing upon any act or matter declared by or under Section 13 to be contempt of parliament by a member and taking the disciplinary action provided therefore. So what this tells us, Chair, is that the conduct which this refers to is contempt of parliament. And of course, you will see that conduct which constitutes contempt of parliament in terms of this act is dealt with under Section 13 of this act. Now, if you go to the rules of the Assembly, now, Rule 10 reads as follows. It says contempt. A member who willfully fails or refuses to obey any rule, order, or resolution of the House may be found guilty of contempt of parliament in terms of the Powers and Privileges Act. Now, Chairperson, we raise this point because our view is that even though the rules define what misconduct is, perhaps let's go to that definition. You will see, Chairperson, there in the definition under misconduct. Oh, there, yeah. It says in these rules, misconduct means a breach of the standing rules of parliament by a member, except a breach of the code of conduct contained in the schedule to the joint rules or conduct amounting to contempt of parliament as defined in the Powers and Privileges Act. So what we want to say, Chair, is that this committee, Chair, deals purely with issues of contempt of parliament and nothing else. That's our interpretation. If you're talking about misconduct, which is defined in the rules, there's another committee in the rules called Disciplinary Committee, which deals with these matters. And of course, if you go to Rule 216, I'm just going there, Chair, now. So 216, about the function and powers of the committee, it says, at the Speaker's request, this committee must investigate any alleged misconduct by a member except a charge against a member of contempt of parliament in terms of the Powers and Privileges Act or a breach of the code of conduct contained in the schedule to the joint rules. So, Chairperson, our submission is that for any matter to serve before this committee, that matter has to be characterized as a matter about contempt of parliament. And of course, if you're looking at what contempt of parliament, the four corners of that, Chairperson, are spelled out in Section 13 of the Powers and Privileges Act. So that's the first point, Chair, we want to make. Now, Chair, I started by saying we want to play devil's advocate because this is what other people on the other side will be doing if this matter leaves this room and go to, and be a subject, of the judiciary. Chairperson, there's an issue about the dome. And perhaps, Chairperson, let me start by just giving members a synopsis of what is encapsulated in the unrevised Hansard. I'll just give a summary. I know we don't have time. If you check at page 5 of the unrevised Hansard, the Deputy Speaker says, I had repeatedly asked you to take your seat, which you ignored, to Mr. Reddy. And Mr. Reddy says, I could not hear you. I did not hear you. And at page 9, something happens because the Deputy Speaker changes the mic and uses another mic. And at page 10, the Deputy Speaker, acting in terms of Rule 23, which is another matter, because remember, if there's a sitting of the House and the presiding officer is presiding, and not as an acting Speaker, which is Rule 24, only the Speaker, in terms of the rules, has the authority to refer matters to this committee. But you will see, for instance, at page 9, the Deputy Speaker says, we will refer this matter to the Powers and Privileges Committee. Now, at page 12, Ms. Kaula from the EFF complains about the sound twice. Now, at page 14, there's a member who complains about, we now see that we have changed the microphone, which means the microphone we were using when we were speaking to Honorable Reddy was not working. At page 15 and 16, Mr. Skosana complains about the sound again. And then at page 16 and 17, the Deputy Speaker says, I will have your microphones and earpieces checked, we'll investigate, and earpieces checked, we'll investigate. At page 19, when Ms. Kaula is speaking, I mean, the Speaker, despite the Deputy Speaker having said, Honorable Member, your time has expired. I mean, Honorable Kaula spends no less than 5 minutes leaving the podium, coming back, and so on and so on. And she's not sanctioned for that. At page 20, Ms. Kaula complains about the sound again. And she says, we have to fix this thing. At page 21, Mr. Nchingila calls for the review of the Deputy Speaker's earlier ruling on Mr. Reddy. And the Deputy Speaker says, we will take everything to the Rules Committee and the Powers and Privileges Committee. And at page 22, Ms. Mkhalibi from the FF raises the issue of two mics and says the issue of two mics and the sound is raised again by Ms. Mkhalibi. And then at page 22, the Deputy Speaker says, we will look into the sound. And then she says, Mr. Reddy couldn't hear me because he was chanting. Now, Chairperson, we are addressing you under the rubric of a case, which is a seminal case, Chairperson, particularly when the right to freedom of speech of members is implicated, which is section 58(1), which speaks about privilege. And that case, which was penned by Justice Madlanga, gives us guidance, Chairperson, in terms of what a disturbance is. When we talk about, for instance, the word interference, what does interference mean, and so on and so on. We will get into that, Chairperson, just now. The other point, Chairperson, we need to raise is that you will recall that the Deputy Speaker had said that he had warned Mr. Reddy earlier. And if you look at the video footage, you will see that the Deputy Minister there for Human Settlements, he rises, he does not follow Rules 92 subsection 3 on what point of order she's rising on. And she gets entertained for more than 50 seconds. If you count the time when Mr. Reddy, for instance, is told to sit down, even though there's an argument that there was a problem with the sound, with the dome, but that's 25 seconds. So I'm just raising these things for members so that when we enter into the discussion, Ms. Kaula, more than 5 minutes. I'm not talking about seconds now, more than 5 minutes. He goes up, at some point he leaves the podium, and then she comes back again, and she's not sanctioned, for doing that. And to us, that's an inconsistency. And of course, if this lands on another forum, we might have issues with that. Now, I just want us to take us to the Democratic Alliance case versus the Speaker of National, it's a constitutional court case. And I know there's a paragraph 38, which presiding officers like to refer to. And I just want to read that for the members as well. And it says that surely the privilege contained in section 58(1)(a) and 71(1)(a) can never go so far as to give members a license so to disrupt the proceedings of Parliament that it may be hamstrung and incapacitated from conducting its business. This would detract from the very raison d'etre of Parliament. Section 57 of the Constitution provides that the National Assembly may determine and control internal arrangements, proceedings and procedures, and make rules and orders concerning its business. But it's also it's also instructive, Chairperson, to also refer to what the judgment said in terms of paragraph 43 when it comes to the reach of the word disturbance. Remember, disturbance is defined in the Act, and I just want to give the members that definition of disturbance before we go to this paragraph. It says disturbance means any act which interferes with or disrupts. So the keywords is interferes or disrupts, or which is likely to interfere with or disrupt the proceedings of Parliament or a House or committee. Now this is what the court said. It said, as a consequence of the application of section 11, a member through removal from the chamber may be deprived of further participation in the proceedings of Parliament for the duration of her or his removal. That does limit the member's privilege under section 58(1) or 71(1). I do accept that the limitation may well be constitutionally permissible, but then the deprivation of further participation in parliamentary proceedings is pegged on the creation of or taking part in a disturbance. Section 1 of the Act defines disturbance. We've dealt with that. Now, Chair, let's deal with the threshold. What does the judgment tells us about, this interference? What is the threshold? Now, if you look at paragraph 44 of this judgment, it says, to warrant removal from the chamber, interference or disruption must go beyond what is the natural consequence of robust debate. Otherwise, the very idea of parliamentary free speech may be eroded. In the heat of a debate, one must expect that from time to time, a member's contributions will not come to a screeching mechanical halt once the presiding officer has ruled that the member desist from further debate on a subject. So what this means is that the court has looked into this, and the court has said, when you are dealing with members, you are dealing with human beings. You are not dealing with inanimate objects. And of course, when you make an intervention as a presiding officer, members' contributions will not come to a screeching mechanical halt. When you say to someone, your time has expired, it won't be after you said expired, then that person, maybe that person was finishing a sentence. That's what the court is trying to say to us here. But then at paragraph 45, it gives us a threshold. It says, interference and disruption that may be sufficient for the removal of a member must be of a nature that hamstrings and incapacitates Parliament from conducting its business. Even so, there must be no anticipation of resumption of business within a reasonable time. That's what the court says. So what we're saying here, Chairperson, is that in Honorable Reddy's case, despite the fact that if you count the time and the sound challenges, and I know for a fact that there was a meeting on the 3rd of April, and Honorable Mani and Honorable Michalakis were part of that meeting. I do have the minutes of that. When the decision was taken that the dome, up until it has been differently configured to look at the sound acoustics and other things, the use of the dome must be suspended from the 7th of April up until the 7th of September. So, in the case of Mr. Reddy, if you watch the footing, you will recall that he was not physically removed. He was sanctioned because once you are told to leave the house, you are not supposed to participate in any business for the duration of that particular day. And that's exactly what happened with him. We raised these issues, Chairperson, because we are worried about the fact that, for instance, if you read the Speaker's referral letter, the Speaker's referral letter, for instance, talks about Rule 7, subsection 1. And Rule 7, subsection 1 says, if the presiding officer is of the opinion that a member is deliberately contravening a provision of these rules, or that a member is disregarding the authority of the chair, or that a member's conduct is grossly disorderly, he or she may order the member to leave the chamber immediately for the remainder of the day's sittings. Now, it says, if in the opinion of the Speaker. Now, Chair, our main worry is that, of course, if we go the route of a full-blown inquiry, we'll have an application here that the Deputy Speaker must come and explain some of the decisions she took on the day and sit on a hot seat as a witness. And I think, Chairperson, it is our duty as well to protect, the dignity of that office. Having raised these inconsistencies, which we're not happy about, our view, Chairperson, is that if you read Section 13, Section 13 places us in the four corners of what contempt of Parliament is. And of course, in terms of the judgment that I've read, it elucidates or explains what interference is, what disturbance is. And we think, based on that, Chairperson, without wasting your time, we think that Mr. Reddy's matter does not fall under the rubric of what we can call a contempt of Parliament. And we are saying, Chairperson, if the members are not with us, insofar as that is concerned, perhaps the matter can be referred to the disciplinary committee. Because if you look at the functions and powers of that committee, it is that committee that deals with issues of misconduct other than contempt of Parliament charges. Chairperson, I'll end it there for now. Thank you very much.
Thank you, Mr. Tejana. Let me afford the members of the committee to deliberate, to have questions of clarity, to engage on the report. Let me start with this side, Honorable Manya. Honorable 3, 4, you will be the last one. Bye. Okay, thank you.
Yeah, thank you, Chairperson. Firstly, I really want to thank the legal team. I think the legal team has done this passionate work to ensure that the integrity of Parliament as a whole is preserved. And I think it is not an accident that the legal team had to make reference to the fact that there's been court cases and all of that, and which this committee has won. But the reference to this one, my reading is that the legal team is saying this is an unwinnable case. I've heard the legal team just indicating a lot of inconsistency. I was there, by the way, in the House when all of this happened. And when they summarize, like they've summarized here, I think it's a brilliant summary and all of that. If we were not politicians here of different political parties, it should have been game over. And then we should say, no, thank you very much, the meeting is closed, there's no case here. But because it's political parties and all of this, now we have to carry on with this discussion. Chairperson, I think let me emphasize the first point that the legal team has made. The technical error of the presiding officer to say that the matter will be referred to this committee. The legal team is saying that on its own is actually erroneous because the legal team says only a speaker can do that. So the fact that the deputy speaker took it upon to arrogate powers to herself is actually on its own an irregularity, as it were. That's the first thing. Secondly, the legal team points out that if this was to go to court, it would actually be very embarrassing to the deputy speaker, and it's something that they don't want to see happening, because the deputy speaker would have to then have to contend with the fact that she had to change the mic. Why would you change the mic if indeed there's no problem with the mic and all of that? And if someone says, I can't hear you, and you change the mic, but you still insist that you should have heard me on the mic that was ostensibly not working. I mean, that is a totally irrational submission for anybody to insist on, Chairperson. The legal team makes a reference as well to some members of the of the House that also rose to complain about the sound. So there's more than enough evidence here submitted to show that there was indeed a problem with the sound. And the last submission made here as well, which disqualified the dome from being in use, is also a documented submission that points to the fact that there's a problem with the sound of that dome. And I don't see why we should be insisting with this, Chairperson, with all the overwhelming evidence that first and foremost at a technical level, there was a problem and there is indisputable evidence to show that there is a problem. To speak here to chair, in fact, if you go to the visuals, you will see the speaker holding a mobile mic next to the one that is fixed on the table. That on its own is evidence to show that there's a problem with the mic that she reprimanded Honorable Reddy on. And then, Chairperson, one of the things about justice is fairness. The legal team points out very clear examples of duplicity by the presiding deputy speaker, where Honorable Kaula was there. She was in and out of podium. She just had her fun on that day. She was in, she was out, she was coming in, she was coming out of the podium. No consequences whatsoever for her on that. Now, where is this regime of law and order? Why did it apply there if we are talking about being orderly here? And then they also make a very important observation that another deputy minister who just rose without even saying what point of order she was rising on or he was rising on, and spent more time being entertained, 50 seconds, more than double the time of 25 seconds that Honorable Reddy is being red-carded for. You know, that duplicity, it's something that would be very embarrassing for the deputy speaker if this matter had to go to court and all of that. Lastly, or towards the end, Chairperson, the legal team makes a very important point that in fact sanction had already been given here because Honorable Reddy was ordered to leave the house. So sanction was provided. So actually this discussion here is an indication of disproportionate amount of sanction that is being considered here, because sanction has been given and the point has been made that once you've left the house, you are denied your privilege to participate and all of that. So you lose that for the entire day. So sanction was already meted out. So what is it that we're doing here, Chairperson? So in conclusion, Chairperson, once again, I really want to thank the legal team, and I want to move, Chairperson, that And also, importantly, people that are not politicians, technical experts, the legal team, have put it on record that the definition of contempt is not met with what has happened. And the legal team is saying, in fact, this committee has got no locus standi to go any further with this matter. This matter does not belong here. And if any further processing of this matter by this committee is in itself irregular, because this committee only deals with contempt of parliament and related matters. This matter that we're dealing with here does not belong here. So this committee should not be, in terms of the legal advice, this committee should in fact not be processing this matter, because this matter falls outside the scope of this committee. I rest, Chair. Thank you.
Thank you, Honorable Manye. I gave you more time because I heard you in one of the committee claiming that you are an elder. So I have to give you more time on the matter, but let me afford other members to have input on the matter. I've noted you, Honorable Paulson, then you'll be followed by Honorable Mahaul.
Thank you very much, Chairperson, and thank you also to the legal team, because I think, you know, it's a correct opinion of the legal team that this matter is unnecessary. I was present in that sitting as well, fortunately, so I have experience about what everyone was experiencing. The sound was terrible, and also if I have to look at Honorable Reddy's behavior, I don't think it was in contempt, but that was my opinion. And also reading the Honorable Reddy's responses, it's also clear that he's still apologetic, even though he had not erred in terms of the rules, and correctly, as the legal team says, is not in contempt. I mean, everyone experienced it. I would just caution the Honorable Mani, you don't prove your innocence by trying to prove someone else's guilt or anything. You know, it's not a practice in law, but I think it's a correct opinion from the legal team as well, and I think the matter should end here. I don't think that Parliament should be seized with, or even the disciplinary committee should be seized with this matter either. Thank you very much, Chairperson.
Thank you. Honorable Mahal.
Thank you very much, Chairperson. Greetings to members of Parliament and the staff of Parliament. I think let's start with the welcoming of the recommendations and the report. It's a well-thought process. Being part of people who sometimes chair sittings, I feel necessary that I must correct something that Honorable Manye said, because it will set a wrong precedence. The Deputy Speaker did not refer the matter to this committee. Deputy Speaker referred it to the Speaker. And then the Speaker referred the matter to this committee. I think if we don't separate that and go to a length of characterizing the Deputy Speaker, one day you will characterize me. And I want to point it out that in the letter that you wrote, Chairperson, to Mr. Reddy, you say, point number 1, the Powers and Privileges Committee is mandated to consider a complaint by the Honorable Deputy Speaker, Dr. Anel Lotrit, which was referred to the committee by the Speaker of the National assembly. It's a very important point. It may sound like it's not an important point. The second point I want to make is that Honorable Paulsen is correct. You don't find ways to absolve somebody from something by wanting to get somebody guilty. By the way, I disagree with the legal team as well as anyone who says the behavior of Honorable Kaula can be equated to that of Honorable Reddy. The reason why Honorable Kaula was in and out of the podium is because the presiding officer has a responsibility when an order is called for the person at the podium to sit down. That is why at the end, Honorable Kaula said, Kwanele Bafethu, I'm not going to be stopped again, because I believe that she was treated unfairly at the time she was supposed to speak. So I don't agree with that. We must equate that point to the possible ill discipline that we are investigating under Honorable Reddy. Having said that, Chair, I do believe that whatever happened there does not constitute a contempt. It will be very difficult to prove it because there was a problem with sound. Almost every day when we are in that sitting, everybody is complaining about the sound. But I don't believe at the end, honorable members, we must say there is no case and leave it like that. And let me tell you why. When Honorable Reddy was ordered to leave, though it was not captured on hindsight, if you read the lips, he was saying the deputy speaker is a racist. Even the gestures he was making were not of a person who is respecting the ruling of the presiding officer. But also, he is respectfully requesting that the matter be resolved through a mediated process. And we should be able to say, next time, there are certain things that you don't do when a ruling has been made. We can't just leave it like that, considering Honorable Reddy's behavior, continuous by the way. Because if we don't do that, tomorrow he will be referred again, doing the same thing, and we have not issued anything that is a warning to him to say, but you are consistent with this behavior that you display. And we must commend that he left voluntarily. Thank you very much.
Thank you, Honorable Maker. Honorable Notata.
No, thank you so much, Chair, and good morning, colleagues. I just want to confine myself to what we're discussing here, because I don't want us to go to Honorable Kaula this and the Deputy Minister that, and it's good that you're playing devil's advocate, but unfortunately we're not in a court of law, and we're dealing with a very specific matter. And what we must determine here is whether there was a wrongdoing. And the bottom line is that there was. And you are quite correct to say, well, the threshold of contempt might not be met, but there is a misconduct there. And we must not try and dilly-dally and be technical about that. The fact of the matter is that there's a wrongdoing that was done. And a wrong done by another member does not cancel a wrong done by this particular member that we're talking about. And it doesn't make it right. So another wrong doesn't make the other wrong right. That's the bottom line. Now, Parliament is not a circus. We're there as representatives of people. Obviously, if you're busy shouting there and chanting, you're not going to hear over and above the fact that there's a sound problem. And that's not something we must be condoning and say, well, it's fine, it's all good and dandy. Calling the presiding officer racist and making physical gestures is not something that we must accept at all. And to just say, look, well, we can't reach the threshold of contempt, and therefore we must just leave it at that, is not acceptable to me personally. And whether there's a process around mediation or this committee taking a formal recommendation to recommend this to the disciplinary committee, something that we must consider, because there's a wrongdoing, there's a misconduct that has taken place. And it's something that we must not condone, but condemn in the strongest terms, so that it doesn't happen again. And aligning myself to the Honorable Maule there, it's quite consistent, and it's something that must be addressed, particularly by this individual member, so that we don't have his name there again, having to consider a referral from the Speaker's office. So, Chair, I would like to suggest that we do consider, as a formal recommendation, one of two things: the requested mediation or formal referral to the disciplinary committee, so that we can deal directly with particularly the conduct of the member in relation to the remarks made when he was exiting the House and the gestures that were made then, which to me I take very seriously, because tomorrow it's going to be someone else sitting here on these chairs, and we're going to be dealing with the same particular issue. So there is a wrongdoing that has happened here, and that's what we must deal with. And we must not compare whether this one was 5 minutes or 2 minutes. Even if it was 1 second, there's a wrongdoing done. There's a breaking of the rules there. And we must deal with it in that sense. Thanks, Chair.
Honorable Vessels.
Thank you very much, Chairperson, and let me also thank the legal team for the work and the advice. I think it is very important that we take that into account. And if one reflects, Chairperson, on the sitting of the 4th of March, then there's no doubt in my mind that it was a very unfortunate sitting, and that the integrity of Parliament did suffer in that sitting because of misconduct from all sides and because of decorum completely collapsing. And that is why I also agree that although one can say that it does not fall and it will not be advisable to take this matter into a full hearing and go further with this matter, it's also not advisable to just say we leave it. I think we should acknowledge the fact that there was misconduct, and the fact of the matter, Chairperson, is that not being able to hear, we all know there were sound problems, but it's a very subjective defense, because in that same sitting where I was sitting, I could hear everything. But I cannot say that the Honourable Reddy were able to hear, because the Honourable Paulson says he couldn't hear, the Honourable Mani says he couldn't hear, but other members that were at the podium did hear. But it's very subjective, and it will be a subjective test, and it won't take us anywhere. I think it was good and is good that we did handle this matter in the fashion that we did, that we received the response from the Honourable Reddy, and that we can look at it like that. If we look at the ruling of the Deputy Speaker, the presiding officer in that sitting, then it's not the mandate of this committee to look if that ruling was valid or not. But the problem is that the contempt, if there were to be contempt, would at the end of the day boil down to the ruling. And that makes it complicated, but that is something, and the inconsistencies that the Honourable Mani refers to in the sitting, that's something that's at the Rules Committee. And that, I think, is something that happens in the National Assembly a lot at the moment, and something that we should address, maybe in our recommendation and in our report. If a ruling is made, you cannot, in the sitting, argue the case if the ruling is valid or not. That can be done at the Rules Committee. A member should leave the House if his ruled and ordered to do so. And that is one of the things that happened in that sitting, is yes, there's a defense of the Honorable Reddy that did not hear initially, but then he did very well hear that he should leave the House, and he refused to leave the House. And that's also a transgression of the rules. And that also contributed to the complete chaos in that sitting. But that is not limited to this one sitting and this one instance. Regardless of all of that, I think a lot of the allegations made, the unparliamentary conduct, alleged unparliamentary conduct and unparliamentary language used by the Honorable Reddy, he denies. It's not unanswered. And unfortunately, the law is not about facts, it's about evidence. And that is why I also do agree that we do not go further with a hearing on this issue and take it further in that regard. But I would support the notion that it is referred to the disciplinary committee, because as other colleagues pointed out, it's not isolated, and there were undoubtedly unparliamentary conduct, and that should be investigated further, but it's not the mandate of this committee. I thank you.
Galega, you'll be followed by Honorable Skosan.
Thank you very much, Honorable Chair. Honorable Chair, let me first appreciate the legal team for the advice they have given the committee, and also emphasize the fact that this committee is expected to be neutral, non-political, but look at the issues at hand and assist the presiding officers to keep the dignity and the decorum of the House. Of course, working together with other committees that are in place, like your DC. So I am not going to be long, Chair, because I think I am covered by the members who have spoken, especially on the facts on the table. One, agreeing that this case of Honorable Reddy does not constitute a contempt. However, there was ill discipline, and there was an undermining of the decorum of the House on the day. And to say, although this committee, based on the facts, won't be able to continue with the case, however, it should be referred to the DC. Why I agree with that, Chair, it is because, as said by the previous speakers, Honorable Reddy, it was not the first time that he displays misconduct or causing rowdiness and chaos in the House. He might not be the only one, but we are dealing with his case now. So, and this committee has to make an example even to other members from any other parties that this is the House of the Republic, and our responsibility as politicians is to debate issues, is to represent the people of South Africa. It's not to behave as if we are ECD children there. That's not a crash. We are adults We are responsible representatives of the people, and debates are allowed, but in a manner that is accordance with the rules of the House. So, and I agree that if we just dismiss and say, no, there's no case, and therefore we close it there, we would be setting a very wrong precedence. So I do second the view that says, yes, on our side, we cannot continue. However, we refer to the DC. Then the DC will, according to the way the DC conducts its affairs, will then deal with it. As I said, that we cannot be setting a precedence. The discipline has to be honored by all the members of the House. Yeah, maybe let me end it there, Chair. Thank you.
Okay, thank you, Honorable Sponsor.
Yeah. No, thank you very much for the opportunity. No, we appreciate the presentation from our legal team advising us on this particular matter. I think their advice, I think, is quite helpful. We really appreciate that. One, let me start on the issue of the Deputy Speaker referring the matter to this committee. From what I heard on the day, the Deputy Speaker said, I'm going to write to the Speaker and ask the Speaker to refer the matter to the Powers and Privileges Committee. I think that's what I remember. Unless maybe she used the words that says, I'm going to refer the matter to the Powers and Privilege. Well, if it's that, I think that was a mistake if she said so. But from what I can recall, she said, I'm going to write to the Speaker and ask the Speaker to refer the matter to the Powers and Privileges Committee. And like Honorable Mahlaule correctly indicated, this matter to this committee was referred to by the Honorable Speaker, not the Deputy Speaker. Because in terms of the rules, I think like our legal team indicated, is that it is the Honorable Speaker who's got the powers to refer matters to this to this committee. So my understanding is that the Deputy Speaker wrote to the Speaker and the Speaker referred the matter to us in terms of the correspondences that we are having. So I don't think we need to fault the Deputy Speaker on that. Because one thing that we must not do as this committee is to make the work of presiding officers difficult. Because as presiding officers, they are chairing the session. Sometimes it's not easy to take an accurate decision. That's why sometimes even when they have to rule on point of orders, they would say, no, I will consult the Hansard, I will come back, because it's very, very difficult just to take a decision on the spot on some of the matters. So if the Deputy Speaker had said, I'm going to ask the Speaker to refer the matter to the Powers and Privileges, I think we need to appreciate that she realized that there's a necessity for this matter to be looked at by a certain committee of Parliament. Even though maybe this may not be the relevant committee to consider this matter. But the fact that the matter has been referred here, I think we need to appreciate that, so that we don't end up as this committee discouraging presiding officer from taking decisions to say, hey, what if I refer the matter there and then that's not the relevant committee, then I will be accused of why I refer the matter, because we've got a number of committees in Parliament. So if a matter lands in a wrong committee, it can always be referred to the relevant committee. So I don't think we need to fault the Deputy Speaker on that, because we might end up discouraging presiding officers from taking decisions in the House. Now, I appreciate the fact that Mr. Reddy has responded to the Audi letter that was sent to him by the chair of this committee. I would really appreciate that. Fundamental issues that Honorable Reddy is raising, which our legal team also raised, the issue of sound of the day, which we all know that there was a problem of sound. Well, it can be subjective, I think, like Honorable Vessels has indicated. However, the difficulty is that we can't prove if Honorable Reddy says, I did not hear because of sound. Because I think there were instances where there was a problem of sound. There was time when sound was fine. There were times also when sound was bad again. There were times when it was also fine. At the time, for instance, because I was also in the house, I can argue that the sound was fine at that time. However, I can't prove if Honorable Reddy can say to me, no, from where I was standing in the podium, I couldn't hear. So it becomes a very difficult thing to prove, taking into account that on the day, there was a challenge of sound. So it's a very important point that I think he is raising in his letter. But the second point that he's raising is the issue of precedence, the issue of chanting slogans in the house, because he's making reference to slogans like pay back the money, which was a slogan that was used to be made by the EFF to the former president Jacob Zuma. The slogan like Ramaphosa must go. Those are precedents that happened in the house where slogans used to be chanted, and unfortunately those matters did not end up in this particular committee. So those are, for me, two important issues that Honorable Reddy is raising. But also appreciate the fact that I think the legal team is advising us that in terms of the contempt of Parliament, these matters, they don't reach that threshold to be classified as the contempt of Parliament. But also the point also, which is also important, the fact that which Honorable Mani, I think, is raising, but also our legal team raised, the fact that a sanction was already given by the Deputy Speaker to say, leave the House, taking into account the rowdy behavior, for the lack of a better word, because in my view, the behavior of Honorable Reddy was rowdy on the day. So, more and above the fact that the matter was referred here, but on the day, the Honorable Deputy Speaker asked Honorable Reddy to leave. Well, after some resistance, he ended up leaving. So he was not physically removed from the house. He left after some resistance on his part. So I think we need to appreciate that at least there was a sanction already that was given to Honorable Reddy on the day to leave the house, and he did, and indeed he left. So taking into account that the advice that says this matter does not meet the threshold to be classified as a contempt of Parliament. So I don't think as this House we can arrogantly want to pursue the matter even when we are advised in terms of that. I think we need to appreciate that advice and fully accept it. However, I also agree with members that we need to look at other mechanisms. I think the firm proposal that was made by Honorable Nodata, that perhaps we need to consider referring the matter to the disciplinary committee. I think that was already seconded by Honorable Vessels and Honorable Galega Mazibuko. I think that will also take care of the proposal that he made in his letter that says he's requesting mediation. Maybe the disciplinary committee may consider taking that route of mediation on the matter. So, see, so that we don't just leave this matter like that. Let's at least take it to the disciplinary committee. If the disciplinary committee also feel that it does not reach a threshold to be a matter where there can be disciplinary action, it's up to them. But if they feel that there's some form of misconduct that warrants some disciplinary procedures, they will then proceed with the matter in that particular light. So because in my view, I think the behavior was somehow rowdy, aggressive, and the fact that he referred to the deputy speaker as a racist, and all those matters, I think the disciplinary committee will have to look at where there's evidence, they will have to act. Where there's no tangible evidence, they will see what to do. But at least as this committee, we can't just leave the matter like that, even though it does not reach the threshold of being a contempt to Parliament. Yeah, but more and above that, Chair, while if we are agreeing that we're saying the matter must go to the disciplinary committee, but as we conclude the matter as this particular committee, I think we need to also caution members about rowdy behavior. That in as much as the committee we feel that the behavior of Honorable Reddy does not constitute contempt to Parliament, but we need to caution members to rowdy behavior, that members must conduct themselves in a parliamentary manner, in a manner that is not rowdy. So we need to make that particular caution, I think, in our conclusion and in our report to the National Assembly, that members must behave themselves in an orderly manner and in an honorable manner as honorable members of Parliament. Thank you very much, Honorable Chair.
Thank you, honorable members. I note this hand, but I just want to say I've given all members equitable time to talk on the matter or to deliberate on the matter. And it would be unfair to me if I open another round of hands because everyone would want to talk. Considering that we said we were having another matter which is presented to us, and also I've listened properly from your deliberations, and I didn't want to interrupt anyone on the matter. As I've listened from... Okay.
I respect your position, Chair, but in a situation where I've also listened to members, didn't disrupt them. In a situation where, I mean, people have mentioned my name here and incorrectly so, must that just be left without being attended to? I wanted to just correct the unfortunate references to my name that were mentioned by some of the members here, misquoting me and all of that. Thank you.
I think you disturbed me because I prepared to talk on that also. It's unfortunate that when we are engaging on certain matters, we make references, either in either cases, being aware or not. But let's take this case as the first case which have been referred to us, and unfortunately, it's having its loopholes as it was presented or as we are being advised by the legal team. That's the unfortunate situation. But that does not make us not to take our responsibility or to discharge our responsibility as delegated committee to look on the issue and to guide against or to defend the integrity of the House. That's our responsibility. We, all of us, when we were deliberating on the matter, said we are indirectly representing citizens, which we all believe that they expect a lot from us as honorable members. We cannot say when other members have done things which are not honorable and we say we keep quiet. If we want to preserve the decorum of the House or the decorum of Parliament. As much as the matter is not a matter which we have to engage on moving forward, but I would conclude taking from your inputs that we feel that we have to refer the matter to the disciplinary committee for all the members to know how to behave when they are in the house. I think let us all appreciate that. That's the first issue. The second issue is if we present the recommendations to the House, I wish we want to send a lesson to all other members on their behavior. Referral was made to other members in the report as much as they were not part of the report, which I believe is correct to make referral because we want to correct all wrongdoings, things which are done in the House by honorable members. So for us, let's appreciate that the administrative and the legal team have brought to us those elements which we have not known of them. It is unfortunate that whenever we refer to Honorable Reddy, we are tempted to address other related issues about his behavior, not about this. That's the unfortunate scenario. But in our report, we'll try and present what was referred to us, but caution other members on the behavior. I appeal to all the members when they are referring to other people in trying to address, they must not misquote them. But if we can open this house for one to defend each other, we can prolong this house unnecessarily. I just hope we cannot continue. But all of us, we must not politicize what have been brought to us. We must live beyond the politics, but with the hope that we want to send a message to the general 400 members of the House and the community members who day in and day out are having interest on our debates and dialogues in the House. I think our recommendation, therefore, seeks to say we'll present the report to the Parliament, but we are recommending that Comrade Reddy be referred to the disciplinary committee. Thanks, honorable members. Honorable Mine.
Chairperson, okay, I'm not going to go to the matter which you've covered about members quoting me incorrectly, and for the reasons that you've already said. I'll just go to the point of the rationale behind referring the matter to the DC. If we were to go to Hansard and listen to the reasons have got less to do with what happened on the day, but on a unrelated historical characterization of Honorable Reddy. And therefore I want to object to this, Chairperson, that we are referring this matter not on the merits of what happened on the day, but purely because we are trying to punish him because of grudge of sorts, because of how he behaved in the past. So I would say because of that, Chair, even referring it to the DC is not warranted. And Honorable Notata made two recommendations, which I want to say, maybe let's consider the other one. It spoke about the DC, but he also spoke about the mediation. So I think given the fact that the referral to the DC is contaminated on its own, because people made reference to historical things that didn't happen on the day, rather the safe route for us to take in order to send a message and not leave it hanging like this, or just drop the matter altogether, just to be seen to have taken this seriously. I want to support Honorable Notata's other recommendation that said mediation. Thank you, Chair.
Okay. It is unfortunate that when you are chairing the meeting, you have to consider the majority view. And Honorable Notata was coming with the two views, but other honorable members said the case must be referred to the DC. I think I've taken the decision based on the deliberations of the House, not undermining any contribution from any member. I think that is the reason. And also the issue of taking other matters which are not related to the day, I think I've spoken on those issues, that they must not be considered. We'll only refer the matter as per the submission which was made by the speaker, based on the referral by the deputy speaker. That's the issue we're taking in. It will depend on the posture of the DC, whether they'll invite any witnesses in their processes. But with us, we are saying we are closing the case, taking it, recommending that Honorable Reddy be subjected to the disciplinary committee. I don't think we'll talk about any other elements. Hence, I said it is unfortunately for him, when we're talking about the person, we have to refer to other incidents, which are, I was trying to caution the members that let's stick to what have been referred in front of us, which is what is written and which was referred to him. And fortunately, he responded to what we wrote to him. But as we are considering, and all of us were saying, this is a matter of a serious nature, but have been addressed to a wrong committee. We are saying, therefore, we don't undermine any structure which is formed by the speaker to deal with ill discipline or matters of contempt of parliament. But we are saying, if there's a structure which is there to deal with the matter, we must not undermine that structure. We must give it the case. It must be that structure, and Honorable Randy, who will call his witnesses to the structure. But with us, we are closing the case. We'll take the report to the parliament. We are referring the case of Honorable Randy to the disciplinary committee. I think that's the closing summary of this. Thank you, honorable members.
Please note the objection of myself here, Chairperson.
Okay. An objection from MKP. Is there any other objection?
Chairperson, just for clarity, we are referring the Honorable Reddy to the disciplinary committee for the allegations that he said the Deputy Speaker is being racist. Is that correct? For what?
For what it was referred to the committee. I think that's my understanding.
Yeah, okay.
For what was referred, not for it. Hence I said, for other cases, we must not judge him based on anything.
Okay.
We are strictly considering what have been referred to us and what has been presented. You'll remember, when the legal team was presenting to the committee, it never referred to any other matters.
Okay.
It's us as members who were tempted, and I guard against that one.
Yeah.
Thank you.
No, correct, Chair. Because my understanding, the legal team says that Honorable Reddy's behavior does not constitute gross disorderly conduct or contempt. So why are we referring this to a disciplinary committee?
Mr. Tejan, can you please, because even this option came from you before I give it to honorable members.
No, Chairperson. Chairperson, the point we're raising is that the committee takes its mandate from Section 12, subsection 1 of the Act, and therefore the committee deals with contempt of parliament issues or matters. So what we're saying is that when we look at this matter, it's not one of those matters we should be serving before this committee. That's why at the end we said, perhaps if there was an alleged breach of the rules, which is misconduct, then the correct structure to refer it to would be the disciplinary committee. Thank you very much.
Okay, thank you.
Through you, Chair.
Let me, because he was making a point of, he wanted to understand. So I want to give it to.
Okay, yeah, Chairperson, I'm at a, look, I don't think the disciplinary committee would be able to find anything that Mr. or Honorable Reddy did that contravenes the rules here. I mean, there's nothing, there's no concrete evidence. I mean, it was chaos that day. We all know. That marquee
Honorable
is
Colvin,
not ideal,
Honorable Colvin, no,
and
no,
for
no,
us
no.
to want
Honorable
to...
Colvin, no. Let's say, let's not think on behalf of the disciplinary committee.
Yeah.
We still have to refer, they will look for their evidence and other things. But with us, we are saying, if it's recommended, remember, we said, the issue is decorum of the house.
Yeah.
As members, we can identify. It was referred to us, but we feel that it does not meet the requirements for us to engage on the matter. If then the prescripts give us an alternative, as honorable members were saying, this case must be referred there. That, I think that's what was raised by the members.
Yeah, thank you, Chair. My closing.
No, I haven't completed
Yeah.
yet, Chair. I'm still on the floor.
Can I?
Yeah, could we... Okay.
What's a point of order?
Thank you so much, Chair. Chair, as the presiding officer of the meeting, the chair of the meeting, you've made a ruling based on a qualitative discussion. You've made a recommendation summary, and you've done that recommendation, that summary. Now, we've opened up a discussion to discuss the summary and the recommendation that has been made by the committee, and I don't think that's the right procedure. We had our formal discussions on the matter. We've made a determination that contempt does not really apply in this particular case, and therefore, as a committee, we're referring this somewhere else. If there's an objection, those objections must be noted, and we move on to the next matter, procedurally. But we can't discuss a summary and a recommendation that this committee has made. I mean, that's procedurally wrong, and I don't think it's a precedent we must set even for the future.
Honorable Notary, I was giving him because I was asking whether there's anyone who is objecting on the matter. And I didn't want to give him, to overlook him because he said he wants clarity. I want him to take a decision. That was the reason why I was giving him to make a follow-up on the matter, not opening the matter. We've noted the objection of Honorable Mani, but I gave him for that specific reason.
Okay. Thank you very much, Chairperson. And as you explained, you feel the matter should be decided upon elsewhere, and I'm comfortable with that. Okay.
I think it's for the
Yeah,
last time.
It
on
is
the
for the
matter.
last time, Chair. No. I was going to say, but this committee is not a complainant. I'm not sure if it's the right thing to refer the matter to anywhere. I think we should refer the matter back to the Speaker and say, Speaker, we've received this matter. After our assessment and advice, it does not belong here. And it must be the Speaker's decision as to whether the Speaker deems it, that it can't be our call.
Okay.
And there's no prescript that gives us
Okay.
a local standard to do that.
Okay, let me give, Mr. Teja.
That's what I wanted to clarify, that, look, loosely speaking, we can't say we're referring it is correct, because it's only the Speaker who can do that. But I think our view as the committee is that this is one of the matters that should be considered by the disciplinary committee, not this particular committee. So it's correct to say it's only the Speaker who can refer it. I mean, it says disciplinary committee at the Speaker's request. That's what the rules say. Thanks.
Okay, I think it's same language, because we were not going to write to the committee anyway. We were to write our report to the Speaker and present the report to the Parliament. That was what we were to do. Okay, you are the last one.
Chair, we have been here before where there was an incident in a couple of years at a joint sitting. The committee came to the conclusion that the matter is not proceeded with, but there are certain recommendations it's making. It made those recommendations to the House. If the House accepts the decision of this committee that the matter it should be referred to the committee, that's it. There is no need for the Speaker to get involved. It will then go automatically to the disciplinary committee. Thanks, Chair.
We are going to take our report to the House. If the House endorses, I think we must be clear on that one. Thank you, honorable members, on the matter. We are noting the objection of MKP. Otherwise, all other members agree with the recommendations. Thank you. I'm looking at the time, but I don't think this will be long, but the time is almost 1:30. The time we targeted 4, because the other admin support have to go to prepare, and this house is a mini plenary house.
I don't know, Chair, maybe we can be quick on this one, the next 15 minutes. Members, we received, after the last meeting, we received a referral from the Speaker. It's a complaint against Mr. Daniels. You'll recall that at the sitting where on the fiscal framework, I think it was on the 4th of, I'm not sure about the date, 2nd of April. During the voting, you members will recall that the Chief Whip of the DA, or the Chief Whip of the Opposition, rose on a point of order to point out that Mr. Daniels had brought in a member when the doors had been closed. Okay. At the time, the House Chair didn't make a ruling on the matter because he still needed to find out more. Subsequently, Mr. Mkalakis followed up with a letter on that matter. The House Chair requested reports on staff who were at the doors. Okay. He got the request, he got the reports. On that basis, he wrote a recommendation to the Speaker, hence the matter came to this committee. Okay. I'll ask my colleague to take it from there, Mr. Tejan. Yeah. Oh, just before we got the Chair, we interacted with the Chair based on Rule 158, Rule 158, which authorizes the Chair to take any steps that are necessary for the work of this committee. One of those things that we did was to write a letter. We felt that there is no need for us to wait for the committee, that the Chair could write a letter to Mr. Daniels and say and point out there are these allegations against you. Do you have any response? And we gave him until the 26th of this month, of last month, and he did respond on the 26th. And my colleague will take it from the Chair.
Thanks very much, Chairperson. Chairperson, just to perhaps preface my discussion by saying, when we write an Audi letter, to an affected member, the purpose of that is for him to state his or her side of the story. And of course, the committee must make an assessment or an evaluation whether on the face of it, there is a case. Now, if you have read Mr. Daniels' version, vis-a-vis the version of the acting Sergeant-at-Arms and Mr. Cousins, who's the police officer who was on duty on that day, you will see that there's a dispute of facts. And of course, as a matter of law, Chair, you can only resolve that via oral evidence. So, if you read Mr. Daniels' submission, it's a conditional apology. He says there was incidental physical contact. I don't know what that means, He also questions the jurisdiction of this committee. He's amongst the documents he requests, he says he requests a video footage. If you look at the pack that was sent to him, Mr. Follick's letter is very clear, the last sentence. The available video footage does not show the incident at the door. So when he wrote to us in response to the invitation to state his side, he was given this letter. But of course, Mr. Follick is acting on the strength of witnesses. Who witnessed, what happened. So the fact of the matter, Chair, is that my view is that we find ourselves in the inquiry territory. Because one of the things, Chair, we must be careful about is to run an inquiry via correspondence. We always say as attorneys, this thing of litigating via correspondence is very dangerous. The least we were expecting was for a simple apology. And then, of course, now Parliament must sit and, if, of course, the committee agrees with us, we need to appoint an initiator so that these differing versions, we can be able to distill some veracity as to what happened on the day. So, Chairperson, without wasting your time, I think our view of it, I mean, on the face of it, of course, is that this committee is being given, you know, a pig's ear to make a silk purse out of it. And we think that having read, I mean, Chairperson, you are at the door, you tell someone that it's closed now, division is taking place, and then he says, no, I just put my forearm next to, no, Chairperson, I mean, yeah. So, Chairperson, our view as the legal team is that we were in inquiry territory now, which is section 12(3). Before a house may take any action against a member in terms of subsection 1, the standing committee must inquire into the matter in accordance with the procedure that is reasonable and procedurally fair. So our view, Chairperson, is that you mandate us to appoint an initiator, and then we inquire on this thing. Thank you very much.
Honorable Vessels, followed by Honorable Nodata.
Thank you very much, Chairperson, and thank you to the committee staff and legal services for the opinion. I agree, and I also propose that we do go over to an inquiry on this matter. It's not only those allegations of the misconduct, but it's also the denial during the sitting that a member came in. In this affidavit, it's admitted that a member came in, and it's then there's the attempt to negate that there's anything wrong with a lot of attempts at constitutionality and equality and lots of things. But the fact is, during the sitting, there was a denial that any member came in. We had to intervene as a lot of members and say, this is the member that came in. And Chair, it's a very important rule, and we can't allow that type of contempt of the rules. So I think there must be an inquiry. If one looks at the differences, in fact, there's also a lot of discrepancies between what is in the affidavit and when one goes and reads the unrevised Hansard, it differs. So it's important to get oral evidence on this and have a full inquiry. Thank you, Chair.
Honorable Nodata.
No, Chair, I don't want to belabor the point. I think let's approve that particular request, and obviously we'll litigate the issues once those particular individuals are here and do the necessary questioning, because I was, for one, the one who alerted the chief whip at the time, because I was at the door to see what exactly was happening. So I don't know what putting a forearm is when you actually push somebody on the side, but we'll obviously litigate those when those come through without belaboring the point. Thanks.
Is there any opposing view? Okay. We agree on the matter. We resolve that a team be investigated and the matter be presented to us after the finalization of processes. Thank you, honorable members. Any
So
other?
quickly, what will happen is that we'll get someone from the outside. We don't prosecute members of staff, someone to prosecute the case. That's what an initiator is, someone that prosecutes the case. And as soon as that person is appointed, then the processes of developing charges and those things will take place, and we'll keep you and the members posted. Thanks.
You have process plan and submit it to the members for the members, at least to be able to follow the processes. Thank you, honorable members, for your time. It's unfortunately that we are only left with 20 minutes before plenary start. Let me thank you for your engagement and views in the committee, your contributions. Thank you indeed. The meeting stands adjourned. Thank you.